Chief Justice Durant, Your Honors, may it please the court.
Yes.
In this case, the Court of Appeals held that engaging in a deliberate course of deception to obtain a court order is not contemptible deceit as a matter of law, as long as the deceit is not directed at the court itself. Moreover, it made this holding.
I'm so sorry to interrupt you, but for our record purposes, I need to get counsel's appearances on the record.
Forgive me.
No problem. So why don't you start with that, Mr. Spencer?
Certainly. I am Stephen Spencer. I am counsel for Holly Rosser, who is the petitioner at the trial court, the appellee before the Court of Appeals, and the petitioner here.
Yes, thank you.
Thank you, Your Honor. I am Nate Mitchell, and I'm here on behalf of the respondent, Ronald L. Rosser, who's listening in to the YouTube streaming, apparently.
Okay. Well, a couple of quick things. If we have a question, we'll indicate it by raising our hands. So you'll probably want to wrap your thought up quickly so that we can get to that question. We have had some technical difficulties this morning, but we'll simply pause the proceedings to work those out. So don't worry if that happens to you. At one time or another, it happens to all of us. Also, while we have allotted you each 20 minutes, should we still be asking questions from the bench? You can continue to answer, and you need not ask permission to exceed your time, and that extra time will not cut into any time allotted you. Okay, with that, Mr. Spencer.
Yes, thank you. Thank you, Justice Durant. May it please the court. In this case, the Court of Appeals held that engaging in a deliberate course of deception to obtain a court order is not contemptible deceit as a matter of law, as long as the deceit is not directed at the court itself. Moreover, it made this holding despite the fact that the issue was neither preserved in the district court or raised in the appellant's opening brief. My client, Holly Rosser, and I ask you to reverse the decision from the Court of Appeals. I would frame the issue or the question presented to this court as follows. This court is called upon to consider whether and how any of the following bear upon the legitimacy or appropriate of the action taken at the district court by Judge Paul Lyman. The doctrine of fraud upon the court and or the inherent contempt powers of the trial judge. And third and last, the statutory given by the legislature in the statute 78B-6-301 or elsewhere, and particularly subsection 4 of that statute. Now, to be clear, I think the most important thing that I have to say to the court is that there is not a good reason to distinguish between the district court's inherent contempt powers and the statutory powers granted by the legislature in 78B-6-301. They are the.
Could I get you to go to what I think is a threshold question, whether we should reach this issue because the issue of the interpretation of this because it was waived, your argument that it was waived, basically,
Yes.
Court of Appeals and not preserved below. So as I look at the Court of Appeals briefing, this is how it looks to me right now, but I am very open to, I'd love to hear your explanation of this. And I'm not asking this as a rhetorical question. I want to hear your pushback. It looks like all along in the district court and in the Court of Appeals, Mr. Spencer was arguing the district court can't do this because Mrs. Rosser is not asking for enforcement of a court order. She's not arguing that he has violated a court order, which is normally what a contempt proceeding or an order to show cause in a family law case is about. And even the local order that you talk about, the one that's for the 6th district, talks about motions to enforce court orders. So generally, these are motions to enforce court orders when you have an order to show cause. And Mr. Rosser is saying she's not trying to enforce a court order. She's not arguing I'm violating a court order. He argues that again in the Court of Appeals, and your response appears to be, well, it's still appropriate. You have various responses, but the one that's at issue before us is it's still appropriate because under statutory contempt, subsection 5 talks about violating a court order, but subsection 4 is more broad and should include what happened here. And the Court of Appeals responded to that argument. And so it seems to me from at this point that the Court of Appeals, of course, had to respond to that. That was your argument about why it was okay for the district court to act as it did, even though this wasn't necessarily about enforcement of a violation of a court order. Can you respond to that and help me understand why that doesn't answer this question about waiver?
Okay, if I understand the question correctly, yeah, let me first say by way of background, of course, we've taken the position this was not properly before the Court of Appeals, and the record is the best evidence of its contents on that point. But I would like to, I understand very well that we're not here to argue about facts, but I would like to call the court's attention to the fact that in looking at the Court of Appeals decision, although it didn't reach the factual issues, that there are statements, especially in the introduction of that decision, that are at odds and are in opposite or diametrically opposed to the findings of the district court. So the nature of our action is we brought this as an order to show cause for a judgment that was procured by fraud. Yes, upon the petitioner at the trial court level, Ms. Rosser, yes, but also is against the court. And so in looking at the paragraph 9R of the decree, it would appear that that possibly we have an integrated agreement, which is an argument that Mr. Rosser made at the district court level. But our argument to the district court is that no, this is not an integrated agreement. Looking at the entire agreement, court, you will see that it is a trick. Okay, it's a clever trick, but nonetheless a trick. The reason that my client ended up having a unpaid tax obligation, I see a hand.
No, please finish your answer.
Yes. But that was our case to the district court, is that although this appears to be an integrated agreement, the stipulated motion order, it was predicated on a prior written agreement that's part of the entire agreement. And looking at that, you can see that my client was already in a position where she wasn't going to owe any taxes, but she agreed to pay the accountant's fee to amend the return, and which showed that she would in fact receive a refund. The district court found that Mr. Rosser was the only one who relevant times understood that she would not, but allowed the deception to go forward. And so
Are you saying that it was in order to show cause that Mr. Rosser had violated the decree? That he had violated the decree? So are you saying we're trying to enforce a court order?
He had violated the entire agreement, but that he had committed a fraud upon the court. His action was deceptive in a way, and that the court should enforce the entire agreement rather than allow his deception to go forward. And in the original appeal before the Court of Appeals, the issue is raised about the sufficiency of the evidence. The issue was also raised about whether the order to show cause is procedurally proper, whether the time had run out under Rule 60B, whether it required a separate action. We submit for the court's consideration that the case law supports the proposition.
Let me redirect you a little bit. And so what I want to focus on though is your argument that Mr. Rosser did not preserve and has waived any argument about subsection 4 of the contempt statute, or even the statutory contempt statute at all. It seems that you're the one who raised that argument as I don't know if it would be completely characterized as an alternative basis for affirmance, but to say why the district court's ruling is appropriate and is within the district court's authority on this order to show cause. And you're saying, well, it's not. I realize in the Court of Appeals you made some arguments that we are saying that he violated the decree, but you also said this also could be just subsection 4, which is broad than violating a court order. And so it seems like it was appropriate for the Court of Appeals to respond to that because that was a legal argument you raised. And it was in response to Mr. Rosser's argument that this shouldn't have happened under an order to show cause because you weren't arguing that he had violated a court order. So can you kind of speak to that specifically about whether we have a waiver of the issue that's before us?
Yes, my argument is that, and I believe it's the Bennett case that speaks to that, that the issue wasn't raised in the opening brief, and I understand the argument is made that I raised it, but I was really just giving background. I mean, my position is that there's not a difference, or at least an important difference here between the statutory powers and the common law powers.
Could I step in here? Because I have a question, Mr. Spencer, that I think relates to Justice Peterson. The threshold problem that I'm having is just sorting out which issues are properly preserved and properly before us. And let me just take a minute and describe the way I'm thinking about how this case unfolded, and you can correct me or agree with me or disagree with me, and help me see it from your perspective. It seems to me that one way to think about what happened at the district court is that nobody was arguing in the district court about whether there was a substantive basis for the district court's exercise of contempt power. That what was being argued at the district court was mostly, or perhaps entirely, whether this was procedurally proper, because there was the argument about, well, this has to have been raised under 60B3, and that's untimely, and the only appropriate mechanism, an order to show cause, to the extent this is an order to show cause, can only appropriately be aimed at the enforcement of an order. And nobody's really arguing about contempt per se. Nobody invokes either the court's inherent contempt power or the statute, because the arguments have to do with procedure. Is this order to show cause the right mechanism? Did you have to do this under a 60B, et cetera? And in fact, when I looked at the hearing in front of Judge Lyman, I looked at the index at the end of the hearing, and the term contempt isn't even listed in the index of the terms that were used. So nobody's even talking about contempt at the district court. And I think it's because at the district court, all the arguments are about the procedural propriety of an order to show cause as opposed to 60B. Let me just stop there and ask you whether you agree with me. And if you agree with me, what does that mean about what the Court of Appeals did? Well, let me finish the thought and add another question to it. That if that's correct, then what seems puzzling to me is the Court of Appeals going off on whether the statute applies, whether there are statutory grounds for contempt power, where the district court itself was never really asked to apply statutory grounds for contempt. That question just wasn't before it. What are your reactions to that?
Yes, I agree that the limitation of the contempt powers were never before the district court. It wasn't a challenge to my motion that was raised.
And where does that leave us? Do you agree with me that what was before Judge Lyman was just the procedural propriety of seeking sanctions, as opposed to whether there's a substantive basis for the exercise of contempt power? And if so, does that mean we reverse the Court of Appeals on that basis, or what? Where does that leave us?
I'm not certain that I understand the question, so I ask like the court's patience if I don't walk down the precise path. But the claims that we made before the district court, okay, is that there had been contemptible deceit that the district court should rectify, and we brought that in the form of an order to show cause. And yes, the arguments were made there that I can't recall what exactly the argument was at the hearing of the district court level, but before the Court of Appeals, the argument was made that the order to show cause is not procedurally proper. But
And
yes.
wasn't that the sort of central question for the Court of Appeals? And yet it seemed to me that the Court of Appeals sort of skipped over that question, at least arguably, and answered instead the question of whether there is substantive contempt power, as opposed to, was this the procedurally proper mechanism to find whether there was deceit? Do you agree with that?
Yeah, yes, I agree that the Court of Appeals skipped over that issue, and they also skipped over the issue of the sufficiency of the evidence, which was the issue that was preserved, the sufficiency of the evidence to find contempt or deceit by clear and convincing evidence. Yes, I would agree with that. And I forgot the second part of your question. I'm sorry.
I guess I've forgotten it too then. I feel like you've answered me, so thank you.
Okay.
I remain confused, and maybe you can help me and opposing counsel can help me. You brought a motion for an order to show cause, which did articulate deceitful conduct as the basis for the order and the relief you were seeking.
That is correct.
Right. What nobody articulated was what the legal basis was for that, but it has to be a contempt order of some sort. I mean, inherent in an order to show cause is a finding of either criminal or civil contempt, right?
I'm not sure that I can answer. I don't know if a finding of contempt is a necessary element to the order to show cause, but I do recall that we
What would it be? I bring an order to show cause that the court should what? Should order what, and what would the basis be? And it seems to me that what you were asking for, maybe I've got this wrong, I just want you to help me think about it, is some form of civil contempt, in that you were trying to make your client whole based on deceitful conduct, alleged deceitful conduct, that had occurred during the hearing, or excuse me, as part of the memorialization of the decree.
That's correct, yes.
Could I piggyback off of this here? Because I think Justice Simonis' question is helpful to me, and his perspective as a district judge is better than mine in this respect. But an order to show cause, I suppose, separate from contempt, could just be to seek an order from the court finding that there was a violation of a court order, which I guess could be contempt, or it could just be entering an order directing people to follow the terms of a court order or something like that. Part of what's puzzling to me about what happened in the district court here is it didn't seem like it was ever really clear exactly on what basis both sides were seeking an order to show cause. I mean, I guess the other side was maybe more clearly focused on the terms of the divorce decree, but that could be a basis for an order to show cause that might not necessarily be contempt, right? Just ordering somebody to comply with a divorce decree.
Yeah, I would agree with that.
I don't understand that. On what basis? I mean, typically we frame these as an order to show cause why X should not be held in contempt for not, I mean, you skip that language, but help me understand what the legal basis would be if it's not a finding of contempt?
Well,
You violated a court order.
it was a finding of contempt, and the finding of contempt was based upon Mr. Rosser's deceit and abuse of the process or proceedings of the court.
I've read the order. I don't have it in front of me right now. Despite your request, did the judge actually use the word contempt?
Yes.
Right. So, I mean, that's my point, is maybe you didn't use it, but at least historically, when we see these motions presented, aren't they, why the respondent shouldn't be held in contempt for failing to pay child support? Why the petitioner shouldn't be held in contempt for failing to pay alimony? I understand that language wasn't used, but it seems to me implicit in the whole order to show cause process, and the trial court certainly understood it.
That may be right, Justice Simonis, and I do have, the order does, in conclusion number 2, does use the term contempt, so this is helpful. Sorry.
Yeah, I don't know that it clears it up for me, because, right, nobody, as Justice Lee has pointed out, and I mean, nobody talks about the basis below.
Yeah, there is still that problem. Yeah.
Yeah.
Sorry. Now it seems like Justice Simonis and I are now questioning each other. So
no, not at all.
My apologies to counsel here. I apologize.
It still remains a valid point. I'm just trying to help frame it.
Yeah.
Okay. And so the question then put to me, I'm not sure that I understand. I apologize.
Here's where I was going, is neither you nor your opponent framed this in terms of, you framed it below, not in terms of Rule 4. You were really arguing, it seems to me, below that there was deceit had been committed, and that deceit is the basis for a finding of an order to show cause, which inherently is the contempt. And there was a factual argument about whether, not only the procedural argument, but a factual argument about whether or not it was really deceitful conduct.
That is correct, and the district court determined that it was.
Yes, and the district court doesn't touch Rule 4. I mean, it's subsection 4. So it's not one of those instances where the district court, on his or her own, embraces the issue. So I guess my question is, why wasn't it incumbent then on the petitioner to say that there was no, and it would be the petitioner's duty to say there was no legitimate basis for the court to have entered contempt? Then the petitioner would have to petitioner Mr. Rosser, I'm getting the terms all messed up. Mr. Rosser would have to say the court erred because there wasn't a substantive basis for the court to enter a contempt violation. And to that end, by not raising it in the opening brief, the petition, I keep saying the petitioner, Mr. Rosser waived the argument.
Yes, that is my position. The arguments that he made in the opening brief was the sufficiency of the evidence and the procedural appropriateness, not the limitation of the court's contempt power. Does that answer the question?
Yes, and I'm going to ask the same question of opposing counsel to solicit their view, Mr. Mitchell.
So, Mr. Spencer, did you at any point give what kind of contempt you were seeking? Did you give the legal basis for the contempt that you were looking for in the district court?
Yes, I would say yes, because I described for the district court first in the motion for order to show cause and supporting documents, like the nature of the fraudulent scheme that I was alleging.
I think that the reason that this is confusing, and it's been confusing for me, is that part of this are the way we talk about orders to show cause. We call it an order to show cause. These are often filed in family law cases, and what it means in shorthand is you think the other person has violated a court order and you're trying to enforce that court order. So looking at the local rule that's in place in the sixth district, so it says when you file your motion, you're supposed to state the title and date of entry of the order or judgment which the moving party seeks to enforce. So there's kind of this presumption that you're seeking to enforce an order that is being violated. And you threw a little bit of a curveball because yours isn't just a straight, here's this order, he's not paying the alimony he owes, he's not paying the child support. You're saying that yours is a little bit different than just a straight, we have an order that the other side is violating. And so doesn't fit into the usual type of contempt that you see in an order to show cause, but we don't see in the district court an identification of what species of contempt you're trying to prove legally. So you don't say we're actually bringing this order to show cause for Mr. Rosser to explain why he's not in contempt for deceit during a court proceeding under subsection 4. We don't see that kind of legal label put on it.
My response is that I believe that the order to show cause is procedurally proper. And one reason for that is the entry of the decree had already occurred. So there's not action like pending before the court to file a motion either under Rule 101 or Title 30. That the fact is the issue was before the court, and I think that Mr. Rosser could have complained about some type of service other than personal service, so that it was important that either his attorney accept service of the motion or that he be personally served, and that he be put on notice of the nature of the claims against him and the relief sought. I think that occurred, and I think the case law that I've cited supports the proposition that it's not necessary or even appropriate to do this as a 60B motion, that the court's plenary contempt powers extend to entertaining such a motion, and that there's really not a reason such as prejudice or any other legal reason why this couldn't be placed before the district court with the motion styled this way.
Counselor, help me understand why 60B was not suited to this. I mean, it seems to address the kind of square hole and round peg nomenclature problem that Justice Peterson has raised, and it seems to me like that's what you really want. You had a judgment based on the stipulation which you argue was entered into based on fraud, and it seems to me like you want that judgment altered to correct this inequity in the tax payments. Help me understand why 60B isn't the better avenue.
Well, Your Honor, an argument is made in the opposing brief that it would have been untimely, which I think on the face of the motion is correct. And the reason it would have been untimely is that the theory of our case, which the district court agreed with, is that Mr. Rosser was the only one who knew anything about his deception until the time occurred that my client received a bill from the IRS, and that happened on about day 109, where Rule 60B allows her 90 days. So she didn't know about it until after that point. But also, my objective, my intention was not to set aside the entire decree and be faced with a proposition of trial or settlement. My intention was to say to the district court, look, this paragraph 9R of the decree was procured by deception or fraud, and but for that deception, we would have had a different result, and the court should, under its contempt power, under its equitable powers, rectify that, which the district court apparently agreed that it could do.
Thank you. Okay.
I see that my time is gone. I think that the other points that I have tried to set out are sufficient briefed in the brief. There are no questions. I'll reserve the remainder of my comments for the time I have on rebuttal.
Thank you, Mr. Spencer. Mr. Mitchell.
Thank you, Mr. Chief Justice, and may it please the court.
Mr. Mitchell, may I start you with the same question? I don't want to suggest outside of family law that order to show cause is always contempt. Let me just be very clear about that. But it seems to me, and based on my experience in the family law arena, an order to show cause is always an order to show cause why the person ordered to pay child support should not be held in contempt for failing to pay. An order to show cause why somebody shouldn't be fined for failing to comply with the decree of divorce or failing to pay taxes. I've never seen another basis for an order to show cause to the best of my knowledge. Have you?
I have not, Your Honor, and while I practice in a variety of areas, one of those areas is family law. And it's my experience that when a motion for an order to show cause is filed in the family law context, ordinarily you seek an order from the court that requires a party to appear and show cause as to why they shouldn't be held in contempt.
That's exactly right. But why isn't the order effectively that? I mean, I grant you the order to show cause didn't say that, but doesn't everybody understand in the family law arena that's exactly what's going on, that there was an order to show cause why your client should not be held in contempt for engaging in deceitful behavior and having Mr. Spencer's client pay $14,000 in taxes? Well, pay $7,000 plus in taxes rather than receive $7,000 plus in taxes?
Well, I think it's important to keep in mind what the motion for an order to show cause actually said in this case, Your Honor.
Yeah, I brought it up just a second ago.
This motion for an order to show cause, to the best of my recollection, I don't believe that it used the term conceit. I think that
I think that was in the substantive memorandum, wasn't it?
I think that may have been the case, but the general thrust and purpose of the motion for an order to show cause in this case was not necessarily seeking a contempt order for deceit. It was seeking a monetary judgment for conduct that was described as fraudulent. And
let me interrupt for just a second and debate this with you a little bit. Isn't that the exact same thing? Isn't the argument that there was fraudulent conduct that led to your client, receiving a windfall of $7,000 and Mr. Spencer's client having to pay $7,000? I mean, if I were to phrase it, is an order to show cause why your client should not be held in contempt for not fulfilling the tax obligations, causing the tax obligations to be visited upon Ms. Roser.
There's a subtle distinction, Your Honor, if I may.
Yes, please, and I'll shut up. The
distinction is this. If you're looking at the terms of the statute, I think the court is correct in comparing fraud to deceit. There are cases that this court has resolved where they look at the use of the statutory term deceit, and they equate the use of that term with common law fraud as it may have been understood at the end of the 19th century. So there is a connection between the two terms. The distinction between what was done in the motion for an order to show cause and what the statute contemplates, however, is that for the purposes of the statute, it has to be deceit in respect to a court or its proceedings, which is arguably different.
And that's below. And that's the problem I'm having, is you didn't make that argument below. The district court judge here found your client in contempt. And I'm wondering why it wasn't incumbent on you in your opening brief then to go through the bases for contempt and say, this doesn't fit, this doesn't fit, this doesn't fit. Therefore, there was no reason, no basis for the district court judge to have entered that contempt order, or even to have raised it below. Right, your arguments below are really vague in terms of no authority, but I think you would have to concede that you never argued that subsection 4 was not a basis.
I think that I couldn't argue that subsection 4 was raised by us. In the Patterson decision, what this court has said is the failure to raise relevant authority can be faulted to both sides, however. And so I don't think that it's necessarily fair to fault Mr. Rosser for not raising it below. And that, again, is why the distinction is a little bit relevant. Justice Lee, I see your hand. May I?
Yeah, if this is a convenient time for me to jump in, I think the Patterson point is interesting, but I guess I see that as probably distinguishable. In Patterson, what we were talking about was our ability to assess additional legal authority in the form of a statute to resolve an issue that was necessarily going to be decided by us. And the distinction I see here, at least arguably, is that we're not talking about the same additional authority in resolving the same issue. It's a different issue. The question whether there is substantive statutory power for Judge Lyman to have entered the contempt order seems like a new issue. And I don't think anybody ever really raised it in the district court. Kind of came up indirectly on the appellee brief and the reply brief in the Court of Appeals, but I think that's too late, and I think it's probably a new issue. And maybe you can tell me what I'm missing there.
If I may double back to the exchange with Justice Homonis for a second, Your Honor, just before I pivot to that issue, because I think that there's a connection between the two of them.
Okay.
The distinction I was attempting to make between fraud and deceit, while they're similar terms and they've been similarly interpreted, the fact that the petitioner in the underlying divorce action used the term fraud provides some context and some understanding for what the legal challenge was. And it is true that there is a distinction between procedure and substance, but there are also cases where they overlap. And the argument below wasn't necessarily raising whether or not subsection 4 extended to these circumstances, but the argument and issue presented below was whether there was any grounds at all for issuing a monetary judgment based on a finding of fraud. And that argument was raised below. It was also raised in the opening brief on appeal. If you look at page 10 of that brief, it says, the court erred in considering the issue of fraud because the proper procedure for obtaining relief from a judgment entered in a divorce proceeding based upon a stipulation is to file a motion under Rule 60b-3. And so it just explains the context of what was occurring.
Yeah, I take that point.
I
take that point, Mr. Mitchell, and I went back and looked at the Court of Appeals briefs with this in mind. I just don't think that sentence that you just quoted, I don't think it's the same point. I think it's going to procedure, and I give you that procedure and substance sometimes overlap, but I don't think what was argued there in the Court of Appeals had anything to do with whether Section 301, sub 4, or any other basis of 301, or the inherent power of the court to award sanction or to find contempt. None of those questions came up as to whether if there's a factual basis for finding that your client engaged in deceit, whether there would be substantive power of the district judge to impose a contempt sanction. I just don't see that having come up at all in the district court. Am I wrong?
That may be the case that subsection 4, it is the case that subsection 4 never came up. I still see that there's a little bit of a connection. If you look at the record of the oral argument, the argument there again was that the relief sought was outside of the order. And so that's not just a procedural argument, it's challenging the substance of the basis of a contempt finding. And that may be compared to the context of a motion for summary judgment for a negligence claim, where one party says that you don't have a duty or you haven't shown the existence of a legal duty, and then the other party identifies and responds to that issue, and then the person who raised the issue responds in reply. That's how things unfolded at the Court of Appeals. There was a challenge to the basis for entering a finding of contempt predicated on a notion of fraud, and the appellee at that point in time raised the statute, and then the Court of Appeals addressed what it perceived as the primary basis for the fraud finding. And so in that respect, I think that this case can be analogized to the Johnson decision or the Lopez decision, particularly the analysis for sua sponte consideration of issues that's discussed in the Patterson decision, where the court discusses when it's a pure question of law that's relevant to the issue before it, it may be appropriate for the court to address that issue in the course of its analysis. It's also consistent with Patterson, although Patterson, the court concluded that the issue was raised and it was a new argument. And I think that that's the distinction between Patterson and Johnson, of course. But in our briefs, we laid out why there might be a basis for addressing the issue under one of three theories. Under the notion that the issue was raised insofar as there was a challenge to the substantive basis for a monetary judgment, insofar as the exceptional circumstances applies. This does present somewhat of a procedural anomaly. The district court never addressed what the basis for its finding was. The movement never identified the statute that would apply. And the statute came up for the first time in the context of appellate briefing, where the appellee was inviting the court to consider an alternative basis for affirmance.
Although, as Justice Simonis pointed out, the district court did say contempt. So the court didn't give a particular subsection of what type of contempt it was, but the district court did say contempt. So did you need to argue in your opening brief, no, he doesn't have the power to hold, or doesn't have the authority, this doesn't fit within the contempt statute, the findings that we have here?
Again, arguably, Mr. Rosser did raise that in two different respects in his opening brief to the Court of Appeals without mentioning the subsection. He challenged whether this was the appropriate procedure, and then he challenged again the factual findings of the district court. And it's true that the district court does reference contempt, and the district court does reference the term deceit, but it's not a term that's used or argued by any of the parties prior to that point. And preservation turns on jurisprudential considerations that involve questions of fairness and judicial efficacy, right? And at this point, Justice Lee.
No, finish your sentence. I'm just sort of signaling that I want to jump in a minute, but finish your sentence, please.
And in our view, there's nothing fundamentally unfair with us responding to an alternative basis for the district court's decision, consistent with the other arguments that were raised, explaining why it's inappropriate for a district court to enter a finding of fraud in a summary proceeding without following the ordinary course.
But one of the things that we've said about preservation and why preservation matters, goes to fairness to district judges and the need for the development of a record that would facilitate our analysis on appeal. And part of the problem that I'm having here in thinking about whether the Court of Appeals interpretation of the statute was correct or not is that Judge Lyman never was asked to apply the statute, and so we have no development of any sort of record as to the level of connection to, is this a deceit that was in respect to a court or its proceedings? I think each side has some pretty decent arguments on where to draw that line and how close the connection has to be to the proceedings in order for it to be in respect to a court or its proceedings. But I'm rather uncomfortable reaching it here in the absence of a district court decision analyzing it.
That's consistent with our position in terms of some of the other arguments that we've raised through the course of this appeal, both to the Court of Appeals and to this court. Our argument has been that if this court were to import the doctrine of frauds or to conclude that it requires fraud on the court, it may be appropriate to remand to the district court for additional findings. The only question is whether or not we need to get to that point. At this point, when it would be remanded to the district court, there might need to be a purely legal decision as to whether or not the statute contemplates only deceit committed on the court or if it also occurs in other contexts. and whether or not a different proceeding, such as an independent action for fraud, which this court has recognized time and time again, might be a better venue for asserting that sort of claim, especially given the protections that discovery affords. Justice Simonis, I'm sorry, I was wrapping up a thought, but
No, you should wrap up your thought, and I appreciate that. You're correct, I believe, based on my review. Deceit on the court was not a phrase that was used. But when you suggest that deceit wasn't used or articulated independent on the court, that's wrong, right? I mean, the word deceit may not have been used, but fraudulently, so to me, deceitful conduct and fraudulent conduct are first cousins, uh, perhaps even closer than that. So to kind of chide the other side for not using the word deceit, but using its synonym, I'm not sure that gets you very far.
the only reason that it may be relevant, Your Honor, is that deceit appears for the first time in the district court's ruling. And so insofar as that term is appearing from somewhere, there's a question as to what standard the district court was applying. And perhaps the inference that could or should be made is the court was applying subsection 4, and then the Court of Appeals was correct in considering whether or not that could be a legal basis for its contempt finding.
Then absolutely you would have had to have raised it in the first instance. If you're saying that the logical inference of the court's order was subsection 4 was being invoked, how in the heck isn't it a pure waiver for you not to raise it in the first instance?
Well, at the district level, we wouldn't have had to notice until the order itself. And so
No, I'm talking about the when I say waiver, I'm talking about the Court of Appeals. I think what you just said is that because the district court judge used the word deceit and it's used in the statute, it's a logical inference that it was referring to subsection 4. Did I misunderstand that?
No, that's correct, Your Honor.
And you were challenging an order in which you're saying implicitly that was the basis, yet you never argued that in your opening brief.
Our opening brief did not address subsection 4. It addressed the proper procedure and whether or not these circumstances gave rise to a fraud under the elements that this court has already recognized.
Mr. Mitchell, can you help me understand? You've talked about fraud and that, that there weren't findings to constitute fraud here. And I agree with Justice Simonis that deceit and fraud are quite close in meaning, but the contempt statute says deceit. It says deceit or, let me find it, deceit or abuse of the process or proceedings of the court, but deceit is just a word by itself. The court says deceit in its ruling. So can you explain to me how your argument about fraud and that the court didn't make sufficient findings, that Mrs. Rosser didn't that there's just not an underpinning for fraud? Why does that matter, and why does that help us with preservation?
I see the issues of the statutory construction, the challenges to the sufficiency of the factual findings, and the preservation issue as slightly distinct, Your Honor. Mm-hmm. With respect to the statutory interpretation, it is true that subsection 4 refers to deceit. There's some interesting comma placement there. But I think that it's fair to read the relevant provision of subsection 4 as deceit by a party, right? And then that section has to be read in light of the introductory phrase. This court has repeatedly said that while the plain meaning of statutes the plain and ordinary meaning of words is important, you have to look at the context in which those terms are used. And the first part of the statute is very important for 2 reasons. The first is that it says the following acts or omissions in respect to a court. And if you look at Merriam-Webster, that usually implies a relation or reference to a particular thing. Where you're using a noun that becomes a verb that takes a direct object. A reasonable interpretation of to deceive in this context is to deceive the court. That's the most reasonable interpretation that's consistent with the purpose of this statute. The second provision of the statute that's fairly important is the end of the introductory clause, which refers to contempts of the authorities of the court. And in our brief, one of the things that we put out there is that there are 12 enumerated grounds for statutory contempt. And in each of those, it is either a representation or an act that's conducted towards the court or one that directly implicates its authority. In our view, the most reasonable interpretation of the statute is not to conclude that a court has sweeping powers to hold someone in contempt anytime there has been a deceit or fraud, but only in those instances where the deceit or fraud is directed at the court.
Was it clear from the beginning that what Mrs. Rosser was asking for is basically an order to show cause because Mr. Rosser was deceitful and engaged in the deceit in order to obtain the court order, to obtain that different language in the decree that says she's going to, instead of the 50-50 of the settlement agreement, in the decree it says she is going to pay for any obligations owed to the IRS, and that he engaged in deceit to get that language into the decree, and that's a court order. Was that clear from the beginning that that was the argument of Mrs. Rosser?
It was not clear, and if the court looks to the motion for an order to show cause, it reads very much like a fraud claim. And in fact, if the other important point to be made is that
could I interrupt here and jump in, because I've got the memo in support of the motion for an order to show cause, and I'm looking at the issues presented, and I think Justice Peterson's question seems like a really important one, and this is the first issue presented in the memo in support of the motion for an order to show cause: whether respondent has violated the terms of the divorce decree, particularly paragraph 9R, or alternatively, whether respondent fraudulently induced petitioner or petitioner's attorney to approve the decree based upon the representation that respondent had paid his share of the tax debt. So why didn't that make it abundantly clear that that there was that connection? It wasn't just sort of fraud in the abstract, but fraud connected up with the decree.
It would have been, it's been we've never disagreed with the notion that the fraud argument might implicate the decree.
Yeah, it's not just implicate. That's not how it's phrased in the memo in support of the motion. Not just that it's implicated, but that it fraudulently induced petitioner's attorney to approve the decree. I mean, that's a really direct connection.
The difference, Your Honor, is that it's not the court being defrauded. It's not the court reasonably relying on a false statement or a false representation in this case. In this case, Ms. Rosser had capable counsel who reviewed the terms of the stipulation and approved the terms of the stipulation, and she signed an agreement, an integrated agreement that became the basis of the decree. And it's one step removed from a fraudulent inducement claim in another context. For the purposes of statutory fraud, the question is whether or not the court was misled. For the purposes of a private fraudulent inducement action, the question is whether or not a person or what the plaintiff was misled. And that's the distinction.
You never gave Judge Lyman an opportunity to rule in your favor on that basis, did you?
Below, there was a challenge to the factual sufficiency of the findings, whether or not it constituted fraud based on what occurred, but the subsection 4 was never specifically raised, Your Honor.
or inherent contempt power or anything else. There was never, Judge Lyman was never given an opportunity to rule in your favor on the ground that even if there was fraud, Judge Lyman, you have no substantive power to impose a contempt sanction. You never gave him that opportunity, did you?
He was given the opportunity to consider whether this was the appropriate procedure and whether or not there could be a fraud, a monetary judgment for fraud brought outside of the time period for 60B3 that was inconsistent with the decree of divorce. That's the question that he did have an opportunity to consider and resolve. Just briefly, I see that I'm out of time. May I address just two other minor points, Mr. Chief Justice?
Yeah, just take 1 minute.
The first point that I'd like to address just briefly is that there is an alternative avenue for relief here that further supports the policies behind narrowly construing the statute so that it doesn't broadly apply in a variety of contexts like discovery disputes or any other point in time where somebody has challenged whether or not a full and fair representation has been made in the context of contentious litigation. And that is an independent proceeding where a party brings a fraudulent inducement claim challenging a contract. And courts have long recognized that they could have that there is inherent authority to set aside an order in that context, and that's equally true here in Utah. The second point that I wanted to address just briefly relates to Justice Peterson's question about the challenge to the factual findings that was made. And that is that it's important to look at the findings that were made in this case when we're thinking about deceit and the interpretation of the statute. There's no specific finding that Ron actually made a false statement, which would ordinarily be required for a fraud claim. There's less of a finding that the court reasonably relied on Ron's false statement. And there's less of a finding that Holly reasonably relied on Ron's failure to make a statement when she independently had signaled to him that there might be a difference that was owed, independently hired her own accountants, and also had an independent relationship with the accountant who prepared the tax returns. And so for those reasons, if this court were to conclude that the Court of Appeals could address the issue sua sponte because it did present a pure issue of law under Patterson, but was to conclude that for some reason the fraud on the court doctrine or some other standard would apply, Mr. Rosser would respectfully ask the court to remand for considerations of those factual questions, either by the Court of Appeals if its standard was incorrect, or the district court if a new standard needed to be applied.
Can I clarify that last point you're making? So let's say hypothetically that we decide you didn't preserve this, so we need to reverse the Court of Appeals decision on subsection 4 because you didn't preserve that argument in the district court. What should we do with that? Do you still have arguments before the Court of Appeals that should be remanded to the Court of Appeals for them to still handle? What happens to any remaining claims?
That's a difficult question, Your Honor, and it's complicated by the fact that Ms. Rosser has filed an independent fraud action against Mr. Rosser that's currently pending, which could complicate that question a little bit. If it went back down to the district court, then there would be a question as to whether or not those two proceedings should or could be consolidated.
Is there anything to remand to the Court of Appeals, though, if we disagree with the if we think the issue was not preserved, and so that overrules the Court of Appeals decision on subsection 4? And I'm not saying that is the decision, but I just want to figure out what the paths forward are in either direction. if we were to say there's no preservation, is there something that needs to be remanded to the Court of Appeals? Remaining, I guess.
The best course may be to remand to the district court for some of the reasons that Justice Lee articulated before with respect to some of it might be necessary to develop a better factual record to address the legal question that's presented in terms of a court's authority under subsection 4. And so for that reason,
could I jump in there? I wasn't suggesting a remand to the district court. I was raising that as a reason to sort of possibly fault you for not preserving this issue. And picking up on Justice Peterson's question, it seems to me that the Court of Appeals didn't reach your argument about the sort of sufficiency of the evidence to support the allegations of fraud. So we have to remand that, don't we?
That would be correct, Your Honor, unless the court were to prescribe a new standard or a new interpretation of subsection 4, and then it might be better to remand to the district court to consider in the first instance. And I apologize if I misstated the point that you were making earlier, Your Honor, but the general observation that I was trying to make is that sometimes for preservation purposes and assessing judicial efficiency or judicial economy, sometimes this court has recognized that factual predicates can be helpful to understanding the legal issues.
Yeah, I understand. Thank you.
If we were to say this was not preserved, though, does your factual argument in the Court of Appeals still stand? And
yes, Your Honor.
Addressed? It still does. Okay. All right.
Okay, thank you very much, Mr. Mitchell. Mr. Spencer.
Your Honor, briefly, I feel that to clarify, with the benefit of hindsight, if I had used the phrase fraud on the court in any of my pleadings at the district court level, that may have been advantageous to me. But in summary, I don't think that the difference is material. I think I've stated that my argument to this court is that the statutory powers outlined in subsection 4 are meant to encompass the inherent or plenary powers of the district court to exercise those in management of those proceedings. And though the elements may be different, there was a sufficient factual and legal basis. The cases I've cited talk about not whether
So I don't totally understand why you would have wanted to say fraud on the court. It seems like it would have been advantageous to use the language of the contempt statute, maybe deceit in respect to the court's proceedings, or something that flagged the contempt statute more. But fraud on the court isn't really, and I could be wrong. I don't know that ties to the contempt statute, is more of Rule 60B concept.
Well, I think that the cases show that the court could entertain such a motion under its inherent powers and without a great deal of limitation to how that motion is styled. But the point that I wanted to make is that the cases that I've cited in my brief, they emphasize whether the fraud interfered with the court's ability to impartially adjudicate, whether it impaired the court's function, whether to do that, whether as the Aoud case, A-O-U-D-E, I believe is pronounced Aoud case, indicates that it has to have broad powers to manage the proceedings. And although the elements of that require a scienter or malice of some kind, as well as a deception, that the elements, although they may be different than slightly different than common law fraud, they're met here in either event.
Mr. Spencer, do you disagree with opposing counsel's position that even assuming that we were to decide this, the argument that Mr. Rosser did not preserve the argument that there was no legal basis for a contempt finding and did not challenge subsection 4. If we were to find that that wasn't preserved, is there still a reason we need to remand to the Court of Appeals? Is there any claim remaining that is still viable by Mr. Rosser in the Court of Appeals if we were to have that finding?
Boy, that is hard for me to answer that. I'm not sure that I understand that piece of appellate procedure as well as I should, but as I understand it, the claim that he raised was not ruled upon, although it was clear to me in the oral arguments that at least one of the justices of the Court of Appeals, did not personally feel that there was sufficient evidence to support the finding by clear and convincing evidence. It never reached the issue or the issues that were presented.
But the thing that confuses me a little bit about that, and we may, and we'll look at this also, but if this is a ruling by the district court based on 301 subsection 4, it's deceit. So I don't know that, so if we say if we were to say there's no preserved argument against this being a matter of the contempt statute subsection 4, which just says deceit, does the factual sufficiency argument in the Court of Appeals still stand? We need to remand for that.
I'm thinking very hard. I'm not coming up with an answer that I love. I'm sorry.
No, that's fine.
I think that, well, I mean, it's a very fact-intensive question about whether there was deceit, and it's also a fact-intensive question whether the theory of common law fraud should apply or the theory of fraud on the court should apply, or both. I'm here making the argument that the theory of fraud on the court applies, and the fact that I didn't use that phrase or talk about the cases that deals specifically with the concept of fraud on the court, it doesn't matter. It's still the law. It's still a basis for affirming, and I'm not the appellant. But I think the question of whether there were facts sufficient for Judge Lyman to determine there was deceit, and I would say that he also determined there was an abuse of process or proceedings on the court, that is Mr. Rosser entitled to challenge the sufficiency of the evidence?
So could I
the
jump
Court of
in?
Appeals never reached that question.
Could I jump in here, because I have the Court of Appeals brief, the appellant's brief of the Court of Appeals up in front of me, and this, I think I see the concern that Justice Peterson is raising. The sufficiency of the evidence argument is based on a common law fraud standard. The lead point in the appellant's Court of Appeals brief is, here are the elements of fraud, and it cites to some of our cases that I think are just common law fraud cases. My question for you is that the standard of fraud that Judge Lyman was applying, and the one that the parties presupposed was the governing standard in the proceedings before Judge Lyman?
Well, I don't think that we can know that with having the ability to read his mind, but it's possible that he employed, either theory. But I would say that, this court could determine that his inherent contempt powers, his plenary powers, were applicable, and that his findings were sufficient under that theory to hold Mr. Rosser in contempt for abuse of process or proceedings of the court, and also deception. I suppose that would leave the issue of the sufficiency of the evidence to make that finding, which the Court of Appeals did not address.
I mean, but this is the puzzle here. I mean, if we send it back to the Court of Appeals and say, you better assess the sufficiency of the evidence, then the question immediately becomes, under what legal standard? And if we've just said the legal standard wasn't preserved, how is the Court of Appeals supposed to assess the sufficiency of the evidence? Because we've told it that the applicable legal standard isn't preserved. This is a real catch-22, I think. And, you know, other than reading Judge Lyman's mind, the other thing to do, which was the basis of my last question to you, would be to look at the papers that were filed before Judge Lyman. What was the legal standard the parties had in mind in the papers that were filed with Judge Lyman? Was it a common law fraud standard, or was it something else? Or was everybody just ignoring it?
Well, with the benefit of hindsight, you know, I can see that it might have been, you know, briefed in more detail, but I think that the question that's ultimately presented is whether he had authority to do what he did based upon the findings that he made. And I think that this court can determine that the answer to that is yes, that he did. He absolutely had the authority to do that based on the findings that were made, which, and I may be skirting like the direct question. As I understand the question, if that issue is not preserved below, how does the Court of Appeals reach it? And the only thing that I can think of at the moment is this court could determine that either under its inherent powers or the statutory powers. I don't personally feel it's important to differentiate. I've said that one embodies the other. I think this court can determine that, which would then leave the issue of whether there was sufficient evidence for him to make that determination under his inherent powers.
I'm super puzzled by what you just said, because a big part of your argument is that we shouldn't reach that question because it wasn't preserved.
Well, and that is in fact the case. I mean, if that was an argument that was raised, I would have responded to it in my appellee brief below. But I'm afraid I can't offer more help than that. But that is correct. That is my position. That was not a challenge that was made either at the district court or at the Court of Appeals.
Okay, thank you.
Thank you very much, Mr. Spencer. Mr. Mitchell, we appreciate your arguments, and we'll take this matter under advisement. Court is now adjourned.